started. Good morning / afternoon to those on the East Coast, and thanks for joining us for Vicente Sederberg's webinar on challenging a cannabis license denial. My name is Jennifer Cabrera. I'm in the New York / New Jersey office of Vicente Sederberg. As many of you know, our firm is unique. We focus on the cannabis and hemp industries and have been doing so for 10 years. So it's a very exciting year, a lot of new states coming on board, but the focus of our webinar today is on disputes. So no one likes to find themselves in a dispute. I know because I run our litigation practice, and it's not a happy place to be always. There are a few different kinds of disputes that clients can find themselves in and out of the cannabis space. On the one hand, you can have contract disputes. These are disputes with business partners or with customers who are usually contract-based. And that's going to be the subject of a future webinar of ours. The focus of today, however, is on disputes with administrative agencies. This is actually a kind of issue that if you are an owner of a cannabis business or license holder, you're more likely to come across this kind of problem in the course of your career than any other. So our point is So our focus today is challenging administrative decisions. We're going to start with a big picture overview of the kinds of issues that can come up, that can be appealed. Then we're going to move on. My colleague, Jericho Perez, is going to discuss the challenges that that have been raised in a number of recent merit licensing denials across the country. Then we're going to pivot to a state-specific focus. We're going to start with Massachusetts. Brandon Kurtzman, partner in our Boston office, is going to cover Massachusetts rules for regulatory appeals. Moving on to California, Andrea Golan in LA office is going to cover California. And then back to my colleague, Jericho Perez, who is the co-chair of our merit licensing group and also our administrative law group. So some very interesting people talking about interesting topics. So I'll turn it over to Jericho first. Thanks.
Thanks, Jen. I'm going to click through some of these. So like Jen said, I co-chair our merit licensing department with Brian Vicente. I've been doing that for 5 years, helped clients obtain licenses in Ohio, Hawaii, New Jersey, really all over the nation, and primarily competitive licensing processes. So what I'm going to talk about is when we have these limited license states, it's usually on the state level, right? How the appeal process works there. So let's think about this. And what we've seen over the years, a lot of these states coming online are obviously new to cannabis. They're going to limit the number of licenses. And they're going to do that through a competitive application process, right? So you spend $500,000 hiring all of these application writers and attorneys, and then you submit this application to usually, Department of Health, Department of Revenue, whatever it may be for that state. And then as we see more states come online and we see more valuable markets like Illinois passing adult use, we're seeing more people applying for those licenses, literally thousands of people at this point. That means sometimes 90% or more of those people aren't going to get licenses. 98% of those people that applied aren't going to get licenses. So I want to talk about first preparing for appeal, because when we're in these competitive licensing processes, it's inevitable that you're going to have issues with scoring and selection, right? Thousands of applications. They normally hire a third-party grader. It's just inevitable there's going to be issues. So what we're seeing now, and what I would recommend is, hopefully you won't have to do this, but that you do prepare for an appeal. You build that into your budget, right? And then the question is, who do you appeal to? That's going to be your first question. That's one of the reasons we recommend hiring counsel as soon as possible. It could be, that's usually in law, you're going to find that you're appealing straight to the court, or a lot of times, I would say most of the time, you're appealing actually to the agency that was responsible for issuing the license. And then you have these procedural issues that you're also going to want to be prepared for probably at the time you apply for the license. you're limited to usually 30 days, right? That's the time limit you can apply for an appeal. So you want to be prepared for that. You don't want to be doing that at the last minute. And then is there an exhaustion of remedies, right? And that kind of goes into who do you appeal to? You have to appeal to the correct venue, the correct agency. We just saw in Ohio, we had a group that missed that deadline, just went straight to the state. The state said, no, you were, per the law, you were supposed to actually submit your appeal to the agency that licensed you. And then, of course, there's open records laws. This is the center of the issues right now in Missouri as far as appeals. Can you get access to somebody else's application to determine if there was arbitrary and inconsistent scoring? And we'll talk more about Ohio here in a minute. So just want to talk about common appeal approaches. Normally what we're seeing, and not necessarily all successful, but there's 3 types of issues on appeal that are very popular. That's unfair or unlawful licensing process. This is sort of, you could see this in Florida, for example, and then it's what we talk about pleading all the issues. You're going to see this really across all appeals. But was the entire licensing process, the whole regulatory scheme, actually unlawful or unfair? And then arbitrary and capricious grading. So inconsistent scoring, negligent scoring, erroneous scoring. I would say in merit licensing scoring-based applications, especially where they're hiring third-party graders, this is going to be our biggest issue. And I would say probably the one you're going to be most successful with. And then bias or corruption. Did the governor's sister own the license? This is also a common theme. We're seeing this in Illinois with KPMG. I would say that's probably a less successful appeal approach, but it's often pled. So let's talk about Illinois. Illinois, we all know, a big issue right now. Right now, we actually don't have a lot of appeals going on. The law in Illinois, actually the rules demanded that you appeal straight to the courts instead of the agency that issued you the licenses. So what we saw was this very, very competitive RFP in 2019-2020 for 75 dispensary licenses. Same thing for cultivation and processing as well. Issues on it. So this is actually a state where I would say 98% of the people that applied didn't get licenses. There were only 21 applicants that received all 75 of those licenses. So you had a lot of people that were very, very upset. The issues on appeal, so actually a group of those denied applicants got together, decided they wanted to appeal, they went to the courts, they said the department failed to follow their own rules. The rules said you had to issue deficiency notices if an applicant was deficient in any area. You didn't do that for everybody, right? I never received one. I didn't get a perfect score. You've got to do that. So filing that one pleading led to the state saying, you're right. You know what? If you drop this lawsuit, we'll rescore and send everybody deficiency notices, give you another chance. So that was presumably very successful. Arbitrary and capricious scoring was another thing, and then there is the bias and the corruption with KPMG. But the primary successful issue there was that they didn't follow their own rules, and it was arbitrary and capricious scoring. Based on that, the state decides to issue deficiency notices, and unfortunately, status-wise, the winners of those licenses filed the lawsuit to try and stop that rescore process from going forward, and now we're all waiting. People have had these properties and applications going for years, so we have yet to see what's going to happen there, but that's Illinois. Iowa, this is actually pretty new. We had the RFP process in 2020 for 2 available medical cultivation licenses. Interestingly enough, all of the losers are actually appealing that for arbitrary and capricious nature of the license award decision. Once all the scoring was released pursuant to the Open Records Act, it came out that there were massive inconsistencies between the 3 graders that graded every application. So that's what's going on there. Those appeals are ongoing. Again, normally with these appeals, they can go on for literally years. And that's why you want to be prepared for them on the front end too. Ohio. So this is one where we're actually seeing the appeals played out. We had the competitive RFP in 2017 for multiple licenses. Tons of people applied, hundreds and hundreds of people. Issues on appeal. So this one's a little bit interesting. Ohio actually had a provision that required a certain amount of licenses to go to economically disadvantaged groups. That provision on appeal was actually deemed unconstitutional and has resulted in multiple licenses being issued. That's primarily because that was a race-based, economically disadvantaged group classification and threshold. So that issue was appealed, and those applicants were successful. There's also arbitrary and capricious scoring, bias, and conflicts of interest. We've also seen multiple successful applicants win on the arbitrary and capricious scoring in Ohio. Missouri. So competitive RFP in 2019 for multiple licenses, issues on appeal, arbitrary and capricious scoring. You know, they had a very, very specific scoring matrix for this. Multiple applicants submitted the exact same applications and received different scores across those applications, which makes no sense. That's where we get erroneous scoring as well. Right now, I think there's literally hundreds of appeals filed in Missouri, and we actually have not seen any of those play out. Now, there are 2 appeals that were not based on scoring, where winners wanted to move their locations, things like that. Those were successful, but we have yet to see what's going to happen in Missouri with these appeals based on arbitrary and capricious scoring. And I'll say the state's literally spending millions on defending these cases. The great thing with Missouri is that Missouri actually, by law, has the ability to issue more licenses. Written into their law is, as far as limited licenses go, the floor, right? So they have to issue at least 50 licenses. It's actually more than that. But that means they have the authority to issue more licenses than that. So I would expect we're going to see a lot of appeals be successful in Missouri. So let's talk about whether you should appeal. What are the considerations? So I would say one of the biggest considerations is, does the licensing agency have authority to issue additional licenses, like we just talked about in Missouri? If that's the case, and you were denied a license and you have a plausible argument for why you didn't win a license and you should have received more points in a certain category, there was inconsistent scoring, you have a higher likelihood of actually getting issued a license. And appeal may be the right choice once you get into this cost-benefit analysis. Do you have time? So again, another one of the reasons we recommend you hire counsel very early on, because of these procedural issues. You're normally only going to have 30 days to file an appeal. So if you've waited 3 months, and not normally 30 days, it could be 60, it could be 90, but if it's 30 days and you've waited 3 months and now you've realized that these people are being successful on appeal, you can't go straight to the courts and appeal anymore because you didn't exhaust your required administrative remedies, which was usually appealing in 30 days to the actual licensing agency. So that's going to be one of your major considerations. And then what are your issues? Like I said before, we're seeing a lot more success in issues that are related to scoring. So did you not receive points that you should have? And does that mean your applications were scored inconsistently? Something like that. Those have a higher likelihood of success of being issued a license. And then what is your goal? Is your goal rescoring of your application? Is your goal an entirely new licensing round next year? Depending on that, you've got this cost benefit analysis. How long do you have to hold this property that you have? How much time and money are you willing to spend on this appeal? So really thinking about your goal, discussing that with your counsel can determine whether it's worth it to appeal. And then I'm going to skip down to the bottom, purchase already appealing applicant. So just a hot tip, it's always an option, purchasing somebody that's actually going through appeal. If there's a likelihood of success there, that'll factor into your cost benefit analysis. And then I'll turn it over to Jen to talk about Massachusetts.
Actually, Brandon.
Thanks, Jen. Thanks, Jericho. So let's talk about Massachusetts. So Massachusetts is sort of a unique state in terms of the regulatory licensing, in the sense that license denials are rare, and that's largely due to the fact that the licensing process is compliance-based. It's not merit-based. So presumably, if you check the boxes and are able to provide everything that the Cannabis Control Commission is asking for, you should be able to get through the licensing process without your license being denied. So there have been two situations, to our knowledge, where the commission has denied an application for a there have been no situations for a final license. There have been two situations where the commission has denied an application for a provisional license. So that basically means that the applicant was in the application process. The application went before the commission for a vote on whether they should be granted a provisional license or not, and the commission decided that that they were going to deny them that provisional license. And what happened in that scenario, and sort of, I'll get back to that, was, they were able to ask for a reconsideration and file appeal in the Superior Court, an administrative appeal in the Superior Court under 30A to challenge this denial. In both of these cases, I believe that the license was ultimately granted after reconsideration, and the action didn't proceed too far in court. And the denial of a license in Massachusetts is considered by the Cannabis Control Commission to be a final decision, and it's the final decisions which are what are appealable in court. So what we see more often, and this is sort of what happens, is threat of license suspension or revocation. And there have been some instances where a license has been suspended, but more often than not, what happens is you will receive a threat of a license being suspended or revoked, and that's in connection with an enforcement action taken by the commission. So it's sort of, these lay out sort of the timeline of what would happen in this situation. So as a licensee, you'll do something that the commission will deem to be a deficiency, and they will notify you that, you did, your inventory was off, or something that was in violation of the regulations. And then once you receive that notice, you're required to submit a plan of correction within 10 days. Now, the commission is required to approve or deny the plan of correction. What we often see is that the commission they don't tell you whether they are approving or denying the plan of correction. Approval generally comes in this form of, they don't pursue the action any further. If the plan of correction is approved or denied, or even if it's approved, what can often happen is you can receive a letter of enforcement intent. And basically what this says is, we intend to pursue a suspension or revocation or invoke fines. And it also gives you the option to request an informal dispute resolution. Now, you can either go forward with the informal dispute resolution, or you can say, I don't want to do this, and then they would proceed to notice you of whatever the violation is in the order, basically suspend, revoke, or fine you. So if you go to step 5 before and you don't ask for an informal dispute resolution, then your remedy would be a formal hearing with the commission. But let's talk first about the informal dispute resolution, because this is what you're mostly going to see in Massachusetts is these informal dispute resolutions. So basically, it's a voluntary process that is not actually contemplated in the regulations. So there's really a lot of gray area in terms of what's supposed to happen at these resolutions in the form that they're going to take. In dealing with these in the past, sometimes they're involved in actual hearings, sometimes there'll be multiple hearings, sometimes there'll be conference calls, sometimes the commission will ask for production of documents. And this is all in an attempt to settle the dispute before they make a final determination, or you decide to proceed to a formal hearing. So as I said, this is in lieu of proceeding with an administrative hearing. And basically, if you're able to work out the dispute with the commission, then they will provide you with a settlement agreement, which basically will be you'll waive your judicial review rights. You'll waive your ability to go to the formal appeal. It's always resulted in, or they've generally resulted in, some form of a fine. We've seen between $50,000 and $350,000, depending on the type of offense. The settlement agreement becomes part of the permanent record of the licensee, and the commission can consider the settlement agreement for future license renewals. So it does have some substantive impacts on the financial and record of the licensee, and this is what we would traditionally see, and this is where most disputes that we deal with are resolved with the commission. If you are unable to resolve it in an informal dispute resolution and you receive a final decision, then you do have a right to a formal hearing. This is also an administrative hearing with the Cannabis Control Commission, and basically it's just a formal administrative appeal process or hearing process similar to the informal, but this is laid out in the regulations in terms of the steps that you have to take in terms of the notice. The hearing officer is appointed by the commission. The burden of proof is on the commission. The conduct of the hearing is under 30A and these adjudicatory practice, rules of practice. At any point during the hearing, you can also settle, and then the ultimate decision of the hearing needs to be approved by the commission. So that's your informal and your formal, and then sort of just briefly, if there is a final decision on your on your license or on some type of enforcement action, and you aren't successful at an informal hearing or a formal hearing, then you have appellate rights, and you basically file action in Massachusetts Superior Court under 30A, and sort of similar to what Jericho said. The court's going to look at whether they exceeded that, the commission exceeded their statutory authority, or whether they acted arbitrarily or capriciously, and some of these other standards to determine whether you can succeed at the appellate level. So that's really just a high-level overview. I'll turn it back to Jen to pass it on to our next speaker.
And this will be my formal handoff to Andrea. Thank you very much, Brandon. That was very informative. Hello, Mrs. Golan.
Good morning, everyone, or afternoon as the case may be. I'm Andrea Golan. I'm an attorney in the Vicente Sederberg Los Angeles office. I'm going to discuss the California state appeals process. This first slide here gives an overview of the entirety of the process, and then the following slides I'll go through each step more in depth. So now CURSA, the Medicinal and Adult Use Cannabis Regulation and Safety Act, provides a statutory right to an administrative hearing for certain reasons, and also a statutory right to an appeal. Now, CURSA requires procedures for hearing an appeal that are similar to those made by the Alcoholic Beverage Control Appeals Board. This is important because there has not been any cannabis appeals yet, so you may need to look to the ABC decisions for precedent. An appeal cannot commence unless an administrative hearing has been conducted and a written decision is made. So you can't go right to the appeal panel. You need to go through the administrative hearing process, which I will discuss. And once the licensing agency issues a decision after a hearing, then an appeal can be made to the appeals panel. And a decision of the panel can be contested by a writ review either in the California Supreme Court or the California Court of Appeal. So, as I mentioned, Malcursa has specified grounds for an administrative hearing. You can't request a hearing for just anything. It has to be for one of the following reasons: denial of an application for license, which is the focus here, of course, denial of a renewal of a license, the placement of a license on probation, imposition of conditions on a license, imposition of a fine or a penalty on a license, canceling, suspending, revoking, or disciplining a license are all grounds for an administrative hearing. The procedures for contesting a denial are contained in the BCC regulations, Title 16, Section 5021. When you receive a denial, you must be notified of your right to a hearing. And you must, if you're going to request a hearing, you must request it within 30 days of your notice of denial. Otherwise, your rights to appeal are waived. The Manufactured Cannabis Safety Branch and California Department of Food and Agriculture do touch on license denial and administrative hearing procedures in the sections that I mentioned here. But the BCC and Malcursa provide the overarching procedures for a hearing and appeal. So when you request a hearing, the licensing agency must file and serve a statement of issues. This is a document that specifies the licensing agency's grounds for the denial or suspension or revocation. So they're required to provide that to you in writing, the grounds for denial. You have a right to discovery at an administrative hearing. Those discovery rules are governed by the Administrative Procedure Act in the Government Code sections 11507.6 and .7. That means you have a right to subpoena witnesses, agency reports, writings, and other documents. The venue or the place of hearing for the administrative proceeding is going to be Sacramento, Oakland, Los Angeles, or San Diego. It's the closest to the location where the transaction occurred or where the respondent resides. You have a right to representation at a hearing and a record of the hearing, a transcript, or you have the option of an electronic recording. I certainly recommend a transcript in case you're not happy with the appeals decision. It's important to have a record to cite to. At the local government level, it's similar, but it's important to check the municipal code for appeal and hearing procedures. It's critical, again, not to miss appeal deadlines. If your notice of denial does not include an appeal deadline, go immediately to the municipal code and check what those procedures are and what those deadlines are. File your notice of appeal timely, and your notice of appeal doesn't need to include all of your legal arguments. You can file your notice and reserve your right to supplement it later on. You need to gather the record, make a record request for all the documents related to the application, scoring process, scoring rubric, anything else that the locality uses to make scoring decisions. You have a right to request those records. You have a right, again, to representation at your hearing. And if you are appealing a decision, procedural arguments are much more likely to prevail than subjective arguments. Saying that your application is better than your competitors is probably won't work. But if you have good procedural arguments about inconsistencies or not following, local procedures, you'll have a much better chance. If you're not happy with a decision after an administrative hearing, then you can appeal your decision to the Cannabis Control Appeals Panel. The appeals panel has yet to hear any appeals. There are currently 2 panel members. We need at least 3 panel members to make a quorum, and I'm sure they will once an appeal has been filed and submitted. Again, timing is critical. You have 30 days to file and serve your notice of appeal and certification of email address. You have to mail those forms to the CCAP and the appropriate licensing agency, include a proof of service. All those forms are available on the ccap.ca.gov website. So they're accessible, they're easy to find. You have 60 days to submit your record to CCAP, and you can request a record from the Office of Administrative Hearings, and that includes any and all writings related to the licensing action, agency reports, transcripts, exhibits, evidence, and so forth. You can file and serve an opening brief and a reply brief. Again, deadlines are critical, and also the requirements are quite technical for the brief. They're contained in the California Code of Regulations 6006. You name it, there's a requirement in there, whether it's headings, margins, page limits, contents. It's really important to read those procedural requirements carefully. Once you file your opening brief, the agency has 15 days to serve an opposition brief, and then you get one more opportunity to serve a reply brief, and it must be served within 7 days of receipt of the licensing agency's opposition brief. You can request a stay. It's not automatic. You can request a stay of the decision of the licensing agency, but it's a very high bar. You can request a stay. You can receive a stay if there's a substantial likelihood that you will prevail and that you'll suffer immediate and irreparable harm if the stay is not granted. So it is possible, but again, it's a high bar. You can appeal the panel decisions. They can be appealed by filing a writ of review in either the California Supreme Court or the Court of Appeal. You have 30 days after the filing of the final order of the licensing agency to apply for appellate review. And agency decisions and final orders of the panel are not effective during the time a writ is pending. And just some practical tips. You want to make sure, again, deadlines are critical. If you miss deadlines, you're out of luck. Your rights are waived. Read the rules carefully. The Administrative Procedure Act is a highly technical statute, so the rules need to be read carefully if you're going to try to do this on your own, which I don't advise. And prepare the record immediately. Get your evidence, documents, request for documents together immediately. Do not wait. And I'll hand it back to Jen.
Thank you, Andrea. And this slide is probably the best advice you'll ever receive for any type of legal proceeding. Read the rules and don't miss deadlines. With that, I pass the baton back to Ms. Perez.
Hi guys, thanks Jen. I'll briefly talk about Colorado and appeals and dispute resolutions here. So nature of Colorado appeals, obviously we have unlimited licensing here in Colorado. We do have dual licensing, which means the locality can limit, prohibit any sort of marijuana businesses. So on the state level, it's going to be rare that you're going to see denials. There's these very clear application criteria, both on the individual and licensed entity level. If you meet the age requirements, you don't have any disqualifying felonies, you have good moral character, which is pretty much a background check, it's highly unlikely you're going to be denied. And if you do get denied, the criteria is pretty clear. So unless there was some sort of mistake on the background check or something like that, it's pretty unlikely that you're going to be denied and need to appeal, or that you would win an appeal in that case. Our licensing authority is the Marijuana Enforcement Division. They are, we call them the Med, and they are under the Colorado Department of Revenue. So the appeal process, if you're looking at an administrative appeal, you appeal straight to the Colorado Department of Revenue. The actual licensing authority is the Marijuana Enforcement Division, but that's right under, that umbrella is under the Department of Revenue. You would, once you get your denial, file a notice of appeal, and then at that point you have the option to actually proceed to a formal hearing. So you're not in state courts here, it is an administrative hearing with an administrative judge. Or you negotiate a settlement agreement order. If it's a disciplinary action, you're almost always, and this isn't an appeal, what's going to happen is you're going to receive a charging document, usually in order to show cause. You go to the AG representing the Marijuana Enforcement Division, and you start negotiating. I would say the biggest tip, if I could give you, is if you do have a disciplinary action, before you enter into a settlement agreement order, because they are going to have form ones that they say, this is the one we send everyone, just sign it, it's a $20,000 fine. There's always, almost always, I would say, room for negotiation. And I would suggest you are represented by counsel, but if you're not, you or your counsel should always negotiate that settlement agreement. There's always room for little tweaks and tips. I see we have a question from Jim Bolin about dispute resolution agreements. And this is exactly what I'm talking about. For dispute resolution agreements, like a settlement agreement order, whether or not you're going to have to disclose that in another state on another application can depend on what's actually in that settlement agreement order. If you can negotiate out having to admit to violations in that settlement agreement order, that may mean you don't have to disclose that to another state that says, have you ever had any violations, right? So as far as that question goes, not necessarily related to Colorado, but we deal with this a lot in Colorado. Number one is, what is that state's disclosure requirement? What's the language? Is the plain reading that they want you to disclose violations? Is it that they want you to disclose any disciplinary action? And then number two, the state or jurisdiction you had that issue in, how did they define it? So in Colorado, we have what's called an assurance of voluntary compliance or a warning letter. Those are specifically done so that you don't have to disclose those in states that ask you if you've ever actually had a disciplinary action or violation. So in lots of states, for example, in Oregon, they actually have come up with a new process. Used to, you had to admit to a violation if there was a disciplinary action, you no longer do, which is great for people that are applying in these national licensing, very competitive application processes. So again, Jim, it really just depends on what the language of the disclosure requirement is, and then how the state you received the administrative action and treats that administrative action. But hopefully there's room for negotiation there, and you can find a way where you don't have to disclose it. Otherwise, any other questions? I'll give it to Jen to moderate our questions.
Thanks, Jericho. It looks like that was our only question in the chat. And we also went a little over, but it was interesting material. Thank you everyone for participating and for joining us online. Please feel free to get in touch directly.